This is one of the shortest Northern Ireland Court of Appeal judgments I've read for many years. Eduardo Yanga was the widower of the late Reverend or Bishop Pat Buckley, who was a well-known ex-Catholic priest who operated outside of mainstream Catholicism. Reverend Buckley died about a year ago, having lived in Larne and ministered there since 1986. In 2012, he claimed adverse possession or squatter's rights over the Roman Catholic property where he had lived and ministered to his oratory congregation. On that occasion, the case was settled by mediation and the terms of the agreement were actually confidential. In this latest Court of Appeal case with Mr Yanga, it was revealed that the 2012 settlement was a caretaker's agreement which basically gave Reverend Buckley the licence to live in that property for the rest of his life. Mr Yanga, who married the late Reverend Buckley in 2010, refused to comply with the terms of the licence, which basically made him get out within 3 months of Reverend Buckley's death. The church asked the court for an order for possession. Mr Yanga represented himself and he failed to convince the court that he had any legal grounds for not complying with the licence agreement. Indeed, Reverend Buckley himself didn't have any rights other than as a licensee, so it's hardly surprising that the Honourable Mr Justice Huddleston said this in court. So you can be in no better position than Bishop Buckley was, and that agreement was terminable on his death. He had no right to be there beyond that, and therefore you have no right to be there beyond that. So in short, you have no defence to the claim that is brought by the parish for possession of the property. For a reason I haven't been able to work out, Mr Yanga was given leave to appeal this, and he essentially brought the same arguments to the Court of Appeal, but also suggested that he should have been granted a tenancy agreement. The Court of Appeal, with the Lady Chief Justice of Northern Ireland sitting, said this: "The judge covered all of the above territory and made an order which is unassailable in law, given the foundational facts of this case. There is absolutely no basis upon which an appeal could be successful in this case, and we therefore dismiss the appeal and affirm the order of the judge." It's hard not to conclude that at least some of the considerations in actually allowing leave to appeal in the first case was down to the fact that the Reverend Buckley was well known, and probably the fact that Mr Yanga wanted to represent himself. In that case, justice probably had to be seen to be done.